Typically in South Africa, when a person has been arrested, they can either be kept in a police cell or in a prison. This is to ensure that they are present for their matter when their matter is in court. When a person does not want to be in custody during the process of their matter, the person can request to be released temporarily on bail. The likelihood of being granted bail depends on several factors. For example, the charge that's being brought against you, the schedule that the charge falls under, and whether you're deemed to be a flight risk. There are different kinds of bail in South Africa. The kind of charge that you are being charged with will determine the suitable bail that can be applied for your temporary release. In South Africa, there are three kinds of bails that we can consider. Firstly, police bail, which is mostly for your minor offences. Secondly, prosecutorial bail, which is for more serious offences. And then thirdly, bail applications in court, formal bail applications for your more severe and serious charges. Let's further discuss the types of bail. We'll start with police bail. In terms of Section 59 of the Criminal Procedure Act, police bail is an option for individuals apprehended for minor offences, allowing a temporary release from custody provided that certain requirements are met. Following an arrest, the accused person is informed of their rights, then transferred to a police station and given an opportunity to make a phone call. Police bail typically applies to relatively minor offences, such as common assault or theft under the amount of 2,500 rands. It is important to note that a schedule of an offence may be upgraded. For example, an offence of common assault, should it include or have elements of domestic violence, it will move from being Schedule 1 to a Schedule 5 offence, meaning that formal bail application will have to be brought and police bail will not be the most suitable bail that can be used in order to temporarily release the accused persons from custody. Initiating the bail application process is typically the role of the criminal lawyer, who navigates the legal intricacies on behalf of the accused. However, the accused person may also bring an application for bail at the police station himself. Should police bail be refused, prosecutorial bail serves as an alternative for the temporary release of the accused persons, with the full authority to grant it vested in the Director of Public Prosecutions or an authorized prosecutor. Should prosecutorial bail not be granted at the police station due to unfortunate circumstances where the prosecutor is not available on standby, then the arrested person must be brought to the court within 48 hours of the arrest preceding the first court appearance so that the authorized prosecutor may grant prosecutorial bail. Prosecutorial bail is exclusive for Schedule 7 offences, which encompasses a range of substantial crimes, including but not limited to fraud, drug possession, robbery, culpable homicide, and assault with intent of causing grievous bodily harm. The decision to grant prosecutorial bail involves carefully evaluating certain circumstances surrounding the case, the nature of the alleged offence, and so forth. The Director of Public Prosecutions or an authorized prosecutor must weigh factors such as flight risk, potential harm to the community, and the strength of evidence against the accused person before determining the bail. Now let's touch on bail applications in court. Formal bail applications may take place in two forms. Firstly, it can be through reading in an affidavit in court. Secondly, witnesses can be called to testify on behalf of the accused, or the accused himself may be called in the box to testify. Briefly, reading in of an affidavit is a situation where the criminal lawyer will be reading in the affidavit on record to the court and handing over the affidavit as an exhibit. The calling of witnesses will be a situation where an examination in chief is conducted. However, this is discouraged as this opens up an avenue for both the witnesses or the accused to be cross-examined. In either scenario, a comprehensive presentation of the case is necessary. Section 60 of the Criminal Procedure Act stipulates that individuals facing Schedule 5 and Schedule 6 charges must bring a formal bail application in court. Schedule 5 offences encompasses grave charges, for example, attempted murder, and drug-related offences, while Schedule 6 encompasses or involves offences in Schedule 5 that are premeditated or repeated, for example, premeditated murder or repeated rape of the same victim. As per Section 50 of the Criminal Procedure Act in relation to Schedule 6 offences, the Director of Public Prosecutions or an authorized prosecutor holds the discretion to issue written directive that a bail application be heard in the regional court if deemed expedient or necessary for the administration of justice.